Good day, Namibia, and welcome back to the Government Information Center. My name is Angela Situmbeko, and I'll be your host for today. So in studio today, my guest will be Ms. Kailiki Sihlahla, who is the Deputy Labor Commissioner at the Office of the Labor Commissioner, as well as Mr. Moses Mazambo, who is an arbitrator at the Office of the Labor Commissioner, and as well as Ms. Mutinta Parker, who is also an arbitrator at the Office of the Commissioner. So our topic today is conciliation and arbitration processes. But before we do get into that, let's welcome our Executive Director at the Ministry of Health and Social Services, Mr. Ben Nangombe. Over to you, sir.
Thank you very much, moderator. I am presenting the COVID-19 update for the week of 11 to 17 August 2022. We recorded 56 positive cases from 1,688 tests conducted, representing 3.3 positivity ratio. Cases were reported from 7 regions. Of the positive cases, 54 are new and 2 are reinfections. The sex distribution is 31 females, of which 30 are new cases, and 25 males, of which 24 are new cases. The ages range from 1 month to 101 years. The regional distribution of the cases is Umsati 28 with 2 reinfections, Khomas 8, no reinfections, Ohangwena 7, Karas 5, Erongo 4, Oshana 1, and Ochodonjupa 1, no reinfections in those regions. Among the confirmed cases, 33 are learners and 5 are health workers and 1 teacher. Of these cases, 2 have received 1 dose of the COVID-19 vaccine, 6 are fully vaccinated, of whom 1 has received a booster dose. 7 cases are not eligible for vaccination, and 41 were not vaccinated. We recorded 18 recoveries from 5 regions during the reporting period, and they are distributed as follows. Khomas region 12, Umsati 3, Ochodonjupa, Kunene, and Zambezi regions 1 each. As at the 17th of August 2022, the number of active COVID-19 cases is 134. 9 cases are currently hospitalized in 3 regions. 1 of the hospitalized cases is fully vaccinated. We have no ICU admission during the period under review. The hospitalizations are distributed as follows: Ohangwena 4, Umsati 3, Oshana 2. We recorded 1 COVID-19 related death during the period. 7-year-old male from Engela district with comorbidities who died at a health facility on the 14th of August 2022. The deceased was not vaccinated. By the 16th of August 2022, a total of 529,000, or rather aged from 18 years and older, have received 1 dose of COVID-19 vaccine, representing 35.9% of the target population of 1.4 million. A total of 196,441 have received the Johnson & Johnson vaccine, while 270,441 adults have received 2 doses of other types of vaccine. Therefore, 466,882 adults have completed their vaccination schedule, translating into 31.7% of the target population. 26,450 children aged between 12 and 17 have received 1 dose of Pfizer vaccine, representing 8.6% of the target population of 307,000. Of these, 13,227 are fully vaccinated. Therefore, the number or the cumulative number of people vaccinated with the first dose, adults and children, is 556,064, of whom 480,100 is 169,665. The newly confirmed cases, as I alluded to earlier, is 54. The reinfections are 2. The recoveries now stand at 165,441, translating to a recovery rate of 97.5%. The active cases are 134. The cumulative dose COVID-19 vaccine for the first dose, 556,064. The second dose, 283,662, now 80,109. The COVID deaths stand at 3,720, COVID-related deaths 350. The total samples tested for COVID-19 in Namibia now stand at 1,074,186. That concludes the update for this week. I thank you very much, moderator.
Thank you very much, Mr. Nongombe, for that COVID update. So getting right back into the topic, our topic for today is conciliation and arbitration processes. But before we do start with the topic for today, I'd like to ask Ms. Isla
through the forms that are involved when referring a dispute to the Labor Commissioner. We also spoke about the consolidation of disputes and whether or not a dispute can be withdrawn.
Okay, thank you. So starting off the topic, could you kindly explain to us the definition?
By a third party would be appointed to assist the parties to resolve the dispute. And conciliator does not impose any decision on the parties, but rather assist the parties to resolve their dispute amicably. While conciliation is also a process whereby a third party is appointed to hear and determine the dispute. And the decision of the arbitrator at arbitration is final and binding on both parties.
Well understood. So if we could go to Ms. Parker. Ms. Parker, what is the purpose of conciliating a dispute of right before it is arbitrated?
Thank you for that question. You see, the purpose of conciliation is for the parties to reach an amicable, quick, and cost-effective solution to their problem. Now, in conciliation, the role of the arbitrator, who has been appointed, who is an independent and impartial person appointed to arbitrate this matter, assists the parties to come up with a settlement that is favorable upon both the parties. In conciliation, the arbitrator does not impose any decisions upon the parties. It is up to the parties to negotiate in good faith and puts in a case of unfair dismissal. And in his or her unfair dismissal claims 10,000, let's say 10,000 Namibian dollars. Now, as the arbitrator, who is the mediator in this conciliation, puts the parties together to discuss and negotiate in good faith, like I said, and see whether they can meet each other halfway. So there's the applicant who is claiming for 10,000 Namibian dollars, maybe the respondent 1,000 Namibian dollars thereafter.
Okay, very well noted. Thank you for that example as well.
Just in addition to
okay.
that, and once a matter has been now settled at conciliation, that disposes of the matter. You cannot now come later and say, okay, when I accepted the 6,000 is because I was going through financial problems and I was going to do ABC.
Understood. Mrs. Latla, if you could kindly just continue, what is arbitration and how exactly does it work, just to provide a clearer understanding?
Okay, arbitration has got different stages, but before you go to arbitration, the arbitrator is required to attempt to conciliate before arbitrating the matter. And then if the parties do not settle, then the matter proceeds to arbitration. Okay, at arbitration, there are stages. Stage number 1 will be the introduction. It's just for the parties to introduce themselves and the arbitrator to introduce himself or herself, and for the arbitrator to know who are the parties before the arbitrator, and also to explain the procedures that are involved or the stages that are involved. Okay, the second one will be the opening statement, and that is an opportunity that is given to the parties to give a brief opening statement and also to indicate the relief that is being sought. The third one is narrowing down the issues, and that normally it is done at conciliation when the parties fail to reach an agreement. And then that is just to try to shorten the proceedings. And the fourth one is the evidence. That is now the stage whereby each party will then present evidence before the arbitrator, so that the arbitrator then can allow them to call their witnesses and so on. And each witness that is being called will be subjected to evidence in chief that is done to the party that has called the witness, and the purpose of that is to elicit facts from the witness, and those facts are going to be used in defense of in defending the case. And then the same witness will be subjected to cross-examination, and in cross it will be done by the adverse party, and that is the opposition, the opposite party. And then we'll then try to elicit also facts from the witness, and try to also sometimes to discredit that witness, so that the case may be ruled in that person's favor, the other party's favor. And then after the cross-examination, the witness will be subjected to re-examination. I normally call it to repair the damage that was caused during cross-examination. Because cross-examination is quite tough, because the other party will try by all means to make the witness be confused and changing statements and so on. And that will also will not go well if the arbitrator has to test the credibility of such witness. So, and after that has been done, then the next stage will be now the closing arguments, or the heads of argument, and that is just for the parties to now summarize what has been done, and also to try to convince the arbitrator that my case is more stronger than the case of the other party.
That was a very detailed explanation.
And after that, analyze that evidence and the closing arguments, and then make a decision.
Okay, thank you for that. Going back to Ms. Parker, are all labor disputes adjudicated only through the Office of the Labor of the Commissioner?
Well, sorry. In some instances, you find in the employee-employer relationship, there could be a company and the employee enter into a contract or collective agreement, and within that collective agreement or that contract, there is a clause stipulating that if there is a dispute amongst themselves, employer and employee, then it would be adjudicated by way of private arbitration.
Okay, understood. And then coming back to Ms. Sihlatla, what are the processes when a dispute has been referred to the Labor Commission?
Okay, I saw that there were the forms were displayed. Can they perhaps?
Yes, we can put the forms back on. Yes. Yes, you can just start now.
Okay, there are two different types of referrals. One is from LC 12, and that is when a trade union is referring a dispute concerning a recognition. Because once a trade union is of the view that it has acquired the majority, may then approach the company to be recognized as an exclusive bargaining agent. But the one that is on the screen now is a referral form of any other type of disputes. It is called Form LC 21, and if you can see there, from 1 to number 4, the referring party is required to complete that information. That is the full name of the applicant, physical address, postal address, the phone, fax, and email. And then when you look at from number 5 to number 8, that is the information of the respondent, and it must be completed in full. And when you look at number 9, that is the nature of dispute. So the referring party is expected to tick one of the disputes that the referring party is referring. And if they are not listed, the dispute is not one of those that are listed there, would then tick under other. And that referring party must specify which dispute exactly. If then, in some instances, the referring party will just say C or refer to summary of dispute. But then the summary of dispute will not summarize will not specify what the dispute is. And the labor commissioner, even if he goes or she goes through the summary of a dispute, will not be able to indicate which dispute exactly. Number 10 is the date on which the dispute arose. This is very important. We spoke about prescription yesterday. Once you indicate the date on which the dispute arose, it will indicate to the labor commissioner whether or not the dispute has prescribed or it has been referred within the prescribed time. And then the referring party must sign the referral form, must print the name and sign, and also indicate the position. And it is indicated representative of the applicant, but in terms of our rules, it's only the representatives that are allowed in terms of the Labor Act to sign this, to represent the parties, to sign this referral. And we are referring now to an office bearer or official of a recognized or a registered trade union. A core employee may also represent and sign the document on behalf of the applicant. And also, if the applicant is a juristic person, like if, for example, a company, then an employee of that company can sign on behalf of the company, because the company does not have hands to sign the document. And then the referral, it is indicating there that a summary of a dispute must be attached here too, stating the subject matter and the facts and circumstances that gave rise to the dispute. And it also requires the referring party to indicate the steps that the party has taken before referring the dispute to the Labor Commissioner. Like we said yesterday, that the Labor Commission is not there to hijack the internal process of the institutions. And then there is another form, which is Form LG 36. It's a requirement that the party must serve the copies on the other parties to the dispute. And then you have to indicate the name of the applicant and the name of the respondent, and this is called also an affidavit of service. This is the proof that you have served. Then you go who your name, and you should indicate the date, the time, and that you have served the documents, and also you should indicate or describe the documents that you have saved on the other party. And then you have to indicate there are 3 options: either to save the documents by hand, by handing a copy, but you have to indicate the full name of a person to whom you have handed the copy. You cannot just say foreman, you have to say the person is Kiliki Sitlahla, and then that person who received the